Hello, my name is Cara Syers, and today I'm going to talk to you about the rules regarding search and seizure in United States public schools, and more specifically Littleton Public Schools, which is the school system where I teach in Centennial, Colorado. Search and seizure laws and rules really are grounded in the Fourth Amendment of the United States Constitution, which specifically says that the right of the people, that people have the right to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, and shall not be violated, and no warrants shall be issued, essentially, except with probable cause. I don't know about you, but that's a little bit complicated for my liking. So in simpler terms, essentially it just means individuals, and in this case, the students in our school system have the right to their privacy and also have the freedom from arbitrary, which means essentially random, invasions or searches. So here it is again in all of its glory, and I guess the rest of this presentation I want to focus on what that looks like in Littleton Public Schools specifically. A lot of the research and rules for this search and seizure law came out of a court case called New Jersey versus TLO. Those are the initials of the girl that was involved in 1985. Essentially, she was caught smoking cigarettes, and they searched her and found the cigarettes, but also found marijuana. And so when they tried to discipline her for that possession of marijuana, she took it to the courts and said that it was a violation of her privacy, and she was searched, illegally according to the Fourth Amendment. The courts actually ruled in favor of the school, and from there we set forth a lot of the rules and regulations that I'm going to talk about next throughout the rest of the presentation. So essentially, in our school district, this law is called Student Interrogations and Searches. It's found in our Student Code of Conduct, and it's officially called our LPS Board Policy JIH. So I just want to talk a little bit about that. The rule begins with reasonable suspicion, which is any suspicion that is based on facts or personal observation. It has to be reported by a reliable informant, so not an anonymous tip. It has to be either a teacher or a student who is basically coming from a trustworthy place. And they basically have to have a suspicion that a search of a person, place, or thing will lead to the discovery of contraband. And according to our Code of Conduct, contraband is anything including drugs, alcohol, guns, knives, other weapons, and incendiary devices, which I didn't know what that was, but I looked it up, and that essentially just means explosives. So if someone observed or has a strong suspicion that a person is in possession of one of these things, then that's reasonable suspicion, and we can proceed with a search. Once a violation is suspected, so there is that reasonable suspicion, then our administration kind of has the right to go down two different routes. They are able to interview potential witnesses and victims and just question them in order to find out more about the incident. This can be done without the consent of a parent or legal guardian. And in regards to the actual suspect, they can interrogate that student. The questions must be focused specifically on the incident, so they can't ask about, everything under the sun. The student has the opportunity to either verbally express or write down their side of the story. And the parent involvement in the questioning is mandatory only if they suspect that expulsion will be the likely consequence. So if it's something serious enough that a student could possibly be expelled. From there, I guess administration has the right to begin a search. So I've kind of got categories of searches, and I'll go through each one. In terms of searching lockers, desks, and storage areas, those, because they're provided for use on school premises, are considered property of the district, and so as a result, they are subject to inspection at any time with or without reasonable suspicion. So everything I've already said kind of goes out the window in the case of lockers and desks. Administration and schools have the right to pretty much search it whenever they want. This also applies to if a locker breaks and a custodian has to go go in and do maintenance. If they want to inspect something, like I said, they suspect something, contraband is in that locker. And I know at our school, probably high school especially, we will once or twice a year just bring in random drug dogs that are sniffing for anything suspicious. And under our school board policy and our student code of conduct, basically they can do that whenever they want because it's school property. This also just in the code of conduct, it also states that locks must be approved by the building. So it's got to be the lock already put on the locker. Students can't double master lock their locker to keep administration out. The rules change a little bit in terms of searching objects that are on an actual student, so the possessions of the student that they're carrying around with them. Reasonable suspicion must be provided, so again, it's got to be witnessed or observed by someone that isn't anonymous, and it's got to be a good hunch that they're carrying some contraband. Once that's in place, then administration has the right to search possessions, which include backpacks, purses, briefcases, computers, cell phones, cameras, pretty much anything on their person. The rules state that one additional person has to be a witness. They don't participate, but they do witness the search, so it's not doesn't turn into a he said, she said sort of issue. And what happens if they do find contraband is that it's confiscated and kept safely at school until the investigation is complete. It might be returned to parents if the issue is resolved, or it might go into the possession of the police, just depending on the issue. Another category of searches, and again this probably only applies to the high school, but that's where I teach, is the search of motor vehicles. Once kids park their car on school grounds, they are essentially giving the school consent to search that vehicle. They are putting it on school property, and so they are consenting that they are following the school code of conduct while the car is there. Again, reasonable suspicion is required, so really the only time it's not is with lockers, desks, and that sort of thing. However, the drug dog searches can be used to establish reasonable suspicion, so they can bring the dogs in whenever they want to the parking lot, and if they get a positive test by that dog, that's considered a reasonable suspicion, and they can proceed from there. The final category of searches that might be, I guess, are probably the most serious is the search of an actual individual or a personal search. Reasonable suspicion is required just like all the others. And in this case, parents or guardians must be notified as soon as possible. This is a serious thing that we're actually searching, the body and the clothing of an individual, and so parents need to be notified. And there are several guidelines in place for how to do that search. It's limited to clothing, just kind of the external clothing items. It must be done out of view of other students, so as privately as possible. And it has to be conducted by a member of the same gender, so males with males, females with females, and it's got to be witnessed by at least one, but no more than 3 individuals of the same gender. So that kind of sums up the basics of searching and seizing property within the Littleton Public Schools Student Code of Conduct. There were a final couple miscellaneous items that I wanted to mention within the code that I felt were important. At any time, building administrators can request that searches be completed by law enforcement. Maybe they feel it's very serious and they would, rather have our SRO, our school resource officer, complete the search, or maybe they're just not comfortable. Maybe there's not a male present and it's a female issue, something like that. But once they do make that request, then those searches are conducted under criminal law rather than school policy. And the final thing that I kind of thought was important to mention was the appeal process. And students do have the right within 10 days of the search to appeal the decision to the superintendent, who will kind of get all sides of the story and make an investigation. And then within 5 days from that issue, he will present his written findings that either, I guess, support the search or, repeal the whole process. And then we would go from there. So hopefully that helps you better understand the Littleton Public School laws and rules surrounding surrounding search and seizure. These are some of the resources that I was using as I completed this presentation, and I just kind of thought this cartoon was a positive way to look at getting searched. You know, who doesn't like a free massage? So thanks, and thanks for listening.